All right. Thank you, everyone, for joining us for today's webinar on employment law updates in DC, Maryland, Virginia, and Illinois. My name's Dan Deacon, and I'm joined by my colleague, Ashley Mitchell. I'm based out of our DC office, and I handle a lot of the employment law issues that come up around the DMV area. And of course, Ashley is based out of our Chicago office, and she'll be handling the Illinois portion of today's webinar. We're going to go ahead and get started with some quick introductions. We have a lot of topics to cover today. There's been quite a bit of activity in all four of these jurisdictions as it relates to new employment laws over the course of the past year or so, and what to look forward to as we move forward in 2022. There's a lot of activity amongst the legislatures coming out of COVID and all that. So as I mentioned, my name's Dan Deacon. I'm an associate here at Carey in our Washington, DC office. I practice in both the OSHA and labor and employment groups, and I handle the array of issues that come through our door, whether it be handling state and federal OSHA inspections, advising and counseling employers on workplace safety and health matters, and anything under the sun, employment law related, FLSA, wage and hour issues, discrimination. So I'll turn it over to Ashley, and she'll introduce herself, and then we'll get into the meat of the presentation here.
Thanks, Dan. Hello, everyone. I'm Ashley Mitchell, and I am based in the Chicago office of Carey. Like Dan, I work in both the OSHA and labor and employment practice groups, and I provide advice and guidance as well as counsel employers on compliance with OSHA standards and a wide array of labor and employment issues as well. Before joining the firm, I worked at a boutique plaintiff labor and employment firm. So I've seen both sides of the L&E litigation, and I look forward to speaking with you all today about the Illinois labor and employment law update.
Excellent. Thanks, Ashley. So as for an agenda today, we don't really need to put up an agenda slide for you all because there's 4 jurisdictions that we're covering, and we're going to go through each one of them, starting with Maryland. And then we're going to follow it up with Virginia, DC, and Ashley is going to finish the presentation with the review of the Illinois employment law updates. So let's dive right into Maryland. They had quite a bit of activity over the past year and a half or so on the employment law landscape. And we're going to start initially here with Senate Bill 450 and House Bill 1393. And what that did was it expanded the definition of harassment under the state anti-discrimination laws, and it lowered the burden of proof for illegal harassment. So this is important because, as many of you are probably aware, the burden of proof, the standard in which a plaintiff would need to demonstrate in a lawsuit claiming illegal harassment would be that that behavior, amongst other things, is severe or pervasive. Well, this Maryland-specific bill removes that requirement in the following situations that involve that unwelcome and offensive conduct. That being submission to the conduct is made a term or condition of an individual's employment, whether that be explicitly or implicitly. 2, submission to or rejection of the conduct is used as the basis for employment decisions about that individual employee. Or 3, it's based on the totality of the circumstances. The conduct unreasonably creates a working environment that a reasonable person would perceive to be abusive or hostile. So this, again, is important for Maryland employers, obviously, because that burden of proof to demonstrate illegal harassment is significantly lower than what has traditionally been the case, certainly under federal law and previously under prior Maryland law. So there can be some, if you want to view it this way, if you are a Maryland employer, it may be more likely that you'll see, if it's a pure illegal harassment lawsuit, that may be a state law claim only, and there may not be a corollary federal claim filed in that complaint to avoid litigation in federal court. So that is one key element that you'll want to be aware of if you see these issues popping up, is that employees do have the option of just proceeding under the state law claim with a lower burden of proof. Finally, this bill also adds a new definition of sexual harassment, and that's conduct that consists of unwelcome sexual advances, requests for sexual favors, or other conduct of a sexual nature. So it's a pretty broad definition that we have there under this new law. Moving on, we're going to talk about statute of limitations for discrimination and harassment claims. And this was promulgated under Senate Bill 451. It's expected, or it will take effect in October of 2022, October 1st to be exact. And what it does is it expands Maryland anti-discrimination law by extending that statute of limitations to file discrimination and harassment claims. So under the current law, up until October 1st, 2022, employees need to file a charge of discrimination with the Maryland Commission on Civil Rights or the EEOC before they file suit. And then they file their claim in state court or federal court, whatever it may be, within 2 years of the alleged discriminatory conduct and within 3 years of the alleged harassment. And I'm sorry, this is for state law claims. So state court. Under the new law here, that will toll the suit filing period when the administrative charge is pending. So as many of you are probably aware, these administrative investigations can sometimes take a long time. And this basically extends that period of time in which someone needs to file their claim in state court by however long it takes that administrative agency to finish their investigation and the conclusion of that pending charge. So it could be extended for several months. It could be even a year or more, depending on how quick that process plays out and when you get that right to sue letter, or when a plaintiff gets a right to sue letter, I should say. The next law that we're going to cover is House Bill 78. And again, this is going to take effect on October 1st, 2022. And what this bill does is it expands Maryland's existing anti-discrimination law requiring employers to provide disabled employees with reasonable accommodations. And of course, there's that exception unless it would cause undue hardship on the employer's business. So this is really something that you all are likely familiar with under the Americans with Disabilities Act, the federal law. So this is just an extension of those protections under Maryland state law. The bill also extends those protections not only to employees, but also to applicants. So for those employers in Maryland, this isn't something that necessarily is new to you from a compliance perspective, because you are complying with these elements under the ADA, but it is now codified in Maryland law, effective as of October 1st, 2022. For the next law we're going to cover here, we're just going to briefly touch on Maryland OSHA's heat stress standard. And this has been ongoing for quite a little bit of time now. It was passed back in 2020, became effective in October of 2020. And what that does is it requires the Commissioner of Labor to develop and adopt regulations related to heat stress on or before October 1st, 2022. Now, Maryland OSHA is going to become one of several states that issues and regulates heat stress through a specific standard, joining California, Minnesota, and Washington. There's one other state that has implemented heat stress rules as well, that being Oregon, in an emergency rule, and they're working on making that a permanent rule now. So there's a number of jurisdictions that are increasing their focus on heat stress in particular, and federal OSHA is also taking a close look at this and implementing taking steps to implement a rule along those lines as well, much earlier in the process, but we certainly advise Maryland employers to keep an eye out for any regulations that may be forthcoming, certainly over the next 5-6 months from Maryland OSHA on heat stress, because as I mentioned, October 1st, 2022 is that deadline. We'll see if that is upheld and whether the Maryland OSHA complies with that deadline. Oftentimes there are extensions, but certainly we expect that those regulations be issued by the end of the year. All right, and we're going to come into our last few slides on Maryland here. First, we're going to talk about recreational marijuana, and the next piece we're going to talk about Maryland's paid family leave law. And these are two laws that aren't quite in effect, or I shouldn't say not in effect, but laws and rules that will be implemented in the future. Let's put it that way. So House Bill 1 is a law that provides for a voter referendum in this upcoming November election, and it proposes a constitutional amendment to legalize recreational marijuana for those that are 21 and older. So as many of you already know, medical cannabis is already legal in Maryland, and there's no employee protections outlined in that law. So it's unlikely that we're going to see any employee protections, anti-discrimination laws spelled out in the recreational context either. And that's, of course, assuming that this referendum passes in a few months here, right? So if it does, we'll see exactly what that law looks like. It wouldn't be legal until January 1, 2023. So there is some time until the specific provisions of this law are really outlined and spelled out as to how that impacts the employment landscape. However, just from a not global perspective, but nationwide perspective, and how other states are handling these issues. The majority of states that have legalized recreational marijuana do not outline any employment or anti-discrimination protections, certainly on the recreational side of things. So we don't expect it to be included in anything that's passed under HB1 either. So finally, this is the next big piece that was recently passed in Maryland and kind of has a long history to it. So Maryland recently enacted the Time of Care Act of 2022, becoming the 10th state to pass a paid family leave law. And this was earlier this spring. It had been percolating around the Maryland legislature for a while. They initially passed it in both the House and the Senate. And then the governor vetoed the bill, and it was quickly taken up just one day later by both houses, both the House and the Senate, and they overrode the governor's veto of this bill. So again, 10th state to pass a paid family leave law, also joining the District of Columbia, who recently passed their own paid family leave law as well. And similar to that law, it's going to be phased in over the next 2.5 years. So the implementation dates are staggered. So the contributions that employers are going to be required to make to the state insurance fund begin on October 1st, 2023. And then employers can begin claiming and receiving benefits on January 1, 2025. So a lot of you may be wondering, oh, well, what are my responsibilities? How much do I need to pay through payroll? So those rates haven't been set yet. They're going to be set by regulation by June 1st, 2023. So we do have some time. Again, this is going to be a 2.5-year rollout period. And there's going to be a staggered deadlines for you to comply with. So those regulations are going to be issued at some point within the next year. So we'll keep an eye out for those and certainly be blogging about them and making sure Maryland employers are up to speed on what your requirements are. But in the meantime, you can check in with your HRS providers and anyone that handles your payroll, make sure that they're set up to handle what the law is going to require. Certainly, if you have operations in DC, you've probably already gone through this process, right? So that's the one proactive step that you can take, is go to your HRS and payroll providers, talk about the law, be proactive about it, and see how you can get this set up and make sure that they're able to handle it, right? So what does the law provide for employees that want to claim and receive these benefits, right? Well, it provides for partial replacement of an employee's wages. It's not 100%, it's up to 90%, up to the maximum of $1,000 per week. And any leave provided under the Maryland Paid Family Leave Law also runs concurrently with any benefits under federal FMLA. So the one caveat to this law is that employers have the option of satisfying the Act's requirements through their own employer-sponsored plan that meet or exceeds the benefits provided under the paid family leave law, and it is approved by the Maryland Department of Labor. So if you are an employer that already provides for paid family leave to your employees as an employer-provided benefit, as long as you're meeting all of those elements of Maryland's paid family leave law, you can apply for an exception, and you don't have to pay that payroll contribution. But there is going to be a process in which you need to apply and be approved by the Maryland Department of Labor to do so. So just keep that in mind if that's something that you wish to continue doing and to keep offering your employees, you can certainly do that. Alternatively, if you want to opt into the insurance fund, you're going to have to do that, of course. So what do employees get? Oh, go back. So eligible employees can receive up to 12 weeks of benefits in an application year for a covered reason. So that's going to be the 12-month period beginning on the first day of the week in which an employee applies for those benefits. However, an employee can receive an additional 12 weeks of benefits if the individual qualifies for both parental leave and a medical leave due to their own serious health condition in that same application year. So what you see on the screen here is the different covered reasons that an employee can receive paid family leave under this Maryland law. And that's to care for a child during the first year after the child's birth or after the placement of the child through foster care, kinship care, or adoption. 2, to care for a family member with a serious health condition. 3, because that covered individual has a serious condition that results in the covered individual being unable to perform the functions of their job. 4, to care for a service member who is the covered individual's next of kin. Or 5, because the covered individual has a qualifying exigency arising out of deployment or a service member who's a family member of that covered. So now we're going to transition into the Virginia law updates. And like Maryland, there's been quite a few employment laws that have been passed over the past year. Virginia has actually been very proactive and somewhat more employee-friendly than many have envisioned over the course of the past several years. And they've been leading the charge in several areas when it comes to progressive employment laws. So first, we're going to start with the disability discrimination and amendments to the Virginia Human Rights Act. And that was under House Bill 1848. And what that does is it amends the Virginia Human Rights Act, making it an unlawful employment practice to discriminate against a worker based on disability and to require employers to make reasonable accommodations for persons with disability. So again, similar to that Maryland law that we talked about, this is a state law that largely is a reflection of the Federal Americans with Disabilities Act. And it's not anything necessarily new to employers, especially those covered under the ADA. So as far as compliance purposes go, this is certainly something that is not new to employers. But again, it does allow employees, aggrieved employees, to ensure that they have the ability to file complaints solely in state court. So next, we're going to talk about House Bill 2147. And what this did was it made a new Office of Civil Rights, which became a permanent fixture of the Attorney General's office. And if a lot of you have been following the news, certainly in Virginia, you know that the Attorney General, Mark Herring, has made several announcements that the Office of Civil Rights and the Attorney General's office is going to be quite active in investigating and eliminating patterns or practices of discrimination. Certainly those related to discrimination, discrimination in public accommodations and housing, protecting new and expectant mothers, combating discrimination against members of the LGBTQ community, and illegal policing. So again, if you've been following the news, you've seen that there's been quite a few notable cases that the Attorney General has gotten involved in. One suing a small city in Virginia, their police force for discriminatory practices. We have the Washington Commanders investigation into harassment ongoing, and the Attorney General is involved in that. So we do expect to see an uptick in the Attorney General's office and the Office of Civil Rights in really taking a strong stance and investigating these claims more so than the prior agencies have in the past. So keep an eye out for those types of claims. Of course, the bill itself outlines the protocols and the process for filing a complaint with the Office of Civil Rights, the investigation period, and the issuance of the right to sue letter. So those specific details are all outlined in House Bill 2147. They're not different from your normal administrative investigation procedures that you see, for example, in the EEOC. It largely mirrors that. But the big point is that the Attorney General's office is spearheading these efforts, and they have made a commitment to really investigating and enforcing these issues. The Virginia Overtime Wage Act is the next. Skip a slide here. Sorry. The next slide that we're going to cover is about military and family member leave rights. This is a new law promulgated under House Bill 2161. And what it is it's designed to create protections for active duty military veterans and their spouses and children. So it largely extends the array of employment discrimination laws in Virginia, including the Virginia Human Rights Act, make it an unlawful employment practice for employers to discriminate against workers based on military status. So again, this is something that we also have on the federal level, and for compliance purposes, it's not something that's all that new to a lot of folks, certainly under USERRA. These employees that are military members, be it reserve or active duty, whatever it may be, they have protections under federal law, and this is just an extension of that into the state law. All right, now onto the Virginia Overtime Wage Act. So Governor Northam signed this act on March 31st, 2021. And what this is basically it's Virginia's version of the Fair Labor Standards Act, but it's not quite an exact replica. So the law obligates employers to pay 1.5 times an employee's regular rate of pay for any hours worked over 40 in a given work week. But there are some key differences in the act. There's certain additional damages that are available to claimants. There is a longer statute of limitations for filing claims. And there is a different calculation method for workers' regular rate of pay. So again, this is significant for employers because if there is a wage dispute and an employee and their attorney do not seek to file any claims under the federal wage laws, they can pursue action in state court under the Virginia Wage Overtime Wage Act. So this does provide a new opportunity for some progressive litigation in state court under wage issues that were previously really not, I shouldn't say not available to employees, but limited in certain capacities that didn't allow for, I guess you can characterize it as benefits for employees and plaintiffs' attorneys. So this law certainly provides some additional resources for employees to seek recourse under just state law. And we're getting into the last few slides on Virginia here. I think we have about 3 left, and then we're going to transition into DC. But we want to mention the increase in the minimum wage. Senate Bill 7 increased the minimum wage from $7.25 to $9.50 effective May 1, 2021, so about a year ago. And it's scheduled to increase until it reaches $15 per hour. So there's going to be a scheduled increase each year. January 1, 22, we had the increase in the minimum wage from $9.50 to $11 per hour. And it's going to increase again on January 1, 2023 to $12 an hour. The General Assembly in 2024 is going to have to reenact or essentially confirm by legislation any additional proposed increases for years 2025 and 2026. Republicans in Virginia have passed several bills in the House seeking to halt the increase in the minimum wage. However, that has been shut down by Democratic-controlled Senate each time. So there was, a couple different bills seeking to halt the increases altogether. There were some that just wanted to pass certain exceptions for smaller employers. But again, all of those were struck down by the Virginia Democratic-controlled Senate. And we're going to continue to see that increase on a year-to-year basis unless something happens down there in the Senate. So key compliance date to keep in mind, it's about 7 months from now, January 1st, 2023. We'll have an increase in the minimum wage in Virginia to $12 an hour. So this is a law about the inquiries into an applicant's salary. And if you attended this webinar last year, you probably heard about a similar bill because this has been around for a while in Virginia. At least the legislature has been trying to pass it. What it does, and it finally was passed, let's put it that way, House Bill 416, it prohibits employers from asking about salary history of applicants. And we've seen a growing number of jurisdictions passing similar laws like this. So it's not surprising to see that this has finally been passed. But if you remember from last year's presentation on the Virginia law update, we did outline all of the elements and the potential fines associated with the current bill that was being proposed at that time. And the fines were actually significantly less. Now, under the current new law, the Virginia Employment Commission can assess fines up to $1,000 for a first-time violation, up to $2,000 for a second violation, and up to $4,000 for a third or subsequent violation. So like I said, the bill passed the Senate in February 2022, and it's likely going to be passed by the House. The House had previously passed a similar bill in 2020, but the Senate was unable to take it up during that 2021 legislative session. So this is something that's going to be likely in effect very soon, and we'll provide an update on that as soon as it is final. All right, the last update here in Virginia is related to the Private Family Leave Insurance Act. And this is Virginia's attempt at providing paid leave for employees, although it isn't mandatory. So what it does is it permits employers to purchase on a voluntary basis insurance policies that provide benefits to replace a percentage or portion of a qualifying employee's income due to the birth of a child or adoption of a child by the employee, placement of a child with the employee for foster care, care of a family member who has a serious health condition, and circumstances arising out of the fact that the employee's family member who's an active duty service member has been notified of an impending call or order to active duty. So again, this isn't a requirement. Employers in Virginia are not required to participate in the insurance policies that provide these benefits to replace a portion of an employee's income for any of those qualifying reasons, but you do have the option to do it. You can make it through amendments to your group disability income policy, or there are separate group insurance policies for you to purchase. And again, this is kind of similar to the DC and Maryland paid family leave laws that we've seen. Certainly those two laws are much more progressive in that they require employers to participate in an insurance fund operated by the state, or in DC's case, the local jurisdiction. But this is the way in which Virginia would like to handle it, purely optional policy at this time. And you can certainly look into these, or you can continue operating as is. So now we're going to move on to the third portion of my piece of the presentation here, and that's the District of Columbia employment law updates. And we're going to start first with some updates on the COVID-19 leave. So on November 18th, 2021, Mayor Bowser signed the COVID Vaccination Leave Emergency Act of 2021, which amended the original COVID leave provision and created a new COVID-19 leave to take effect November 5th, 2021. That new COVID leave is unpaid, but an employee can use accrued paid leave, which counts against the 16-week entitlement provided under DCFMLA. And we're going to get right into exactly what type of leave you get, right? So starting November 5th, 2021, an employee who has worked for 30 days for an employer with 20 or more employees in the district can use up to 16 weeks of new COVID leave for one of the following reasons: a positive test result, isolation or quarantine, care for others, or the closure of a child care center. So the positive test result, obviously that's if an employee tests positive for COVID-19 or needs to care for a family member or individual with whom the employee shares a household that's tested positive or otherwise has been ordered to quarantine by Department of Health. Two, the isolation or quarantine reason, that's where an employee has a recommendation from a healthcare provider or a directive from an employer to isolate or quarantine due to COVID-19. The care for others, the third option there, that's where an employee needs to care for a family member or someone that they share a household, whether they're sick or isolated because of Department of Health orders or guidance or the recommendation of a healthcare provider. And then fourth is the child care closure, where an employee needs to stay at home to care for their child because their daycare, their preschool, or their place of care is closed or otherwise unavailable due to a COVID-19 reason. COVID-19 vaccination leave. Now, this is something that Mayor Bowser signed in December of 2021. That's the COVID-19 Vaccination Leave Temporary Act. And what it did is provide paid leave to an employee for an absence related to a COVID-19 vaccination for either themselves or their child. And that child is defined as someone under the age of 18 years old. And what the employee is entitled to is for vaccination leave up to 2 hours per injection, and for vaccination recovery leave up to 8 hours per injection during the 24-hour period following the 2-hour vaccination leave period. And note that an employee is not entitled to anything more than 48 hours of leave in a total year. So that's combined for themselves and any children, right? And eligible employees are those that began working at least 15 days before the request for leave is submitted to the employer. So this is pretty much applies to all employees, including new employees that have been there for at least 2 weeks, basically. They need to be paid at their regular rate of pay, and the leave needs to be provided in addition to any other leave that the employer provides under your existing leave policies or DC Sick and Safe Leave. This is an additional leave bucket. All right, the Universal Paid Leave Law. So this is an exciting time for both employees and employers in the district. The recent announcement of the updates to DC's Universal Paid Leave Fund. There was a surplus in the fund that prompted some changes that are pretty exciting, like I said, for both employees and employers. The law has been in effect for quite a while now. July 2020, it allowed employees in DC that work in DC to take up to 8 weeks of leave for parental leave, 6 weeks for family medical leave, and 6 weeks for personal medical leave. And as of July 1, 2022, employees are now going to receive 12 weeks for parental leave, 12 weeks for family medical leave, and 12 weeks for personal medical leave. So that's, almost double the amount of leave for family and personal medical leave purposes. and an additional 4 weeks for parental leave. And on top of that, eligible employees are also now entitled to a new benefit of 2 weeks of paid prenatal leave, which was not previously available. So again, this is going to be as of July 1, 2022. And the exciting piece for employers is that the payroll tax rate that employers contribute to is going to be cut by more than half the current rate. So the current rate is 0.62% of an employee's salary, and the new rate is going to be 0.26% of an employee's salary. So that change is expected to result in a saving of $202 million for employers in the first year alone. Just right for DC employees, that's quite significant. There's going to be even more changes to the Universal Paid Family Leave Act in the near future, something to keep an eye on. For example, there's a new bill that was introduced by council members in February that would make benefits portable, meaning that workers who are fired or otherwise lose their job are still going to be able to take advantage of those benefits that their employer had paid for through the payroll tax and that are in the fund. Currently, only employees can claim benefits if, of course, they're still employed, which may and tends to have a negatively low or impact on low wage workers in industries with some higher turnover. So keep an eye out for some additional bills and new laws that are going to be passed likely over the next year or so as it relates to the Universal Paid Leave Law. And finally, we'll wrap up the DC update here with a discussion about the increase in minimum wage. So beginning on January 2022, DC's minimum wage increased to $15.50 per hour for all workers, regardless of the size of the employer. And we're going to have another increase on July 1, 2022 to $16.10. And the base minimum wage for tipped employees is going to increase to $5.35 per hour. So we do have that coming up in about a month and a half, something to keep an eye on and make sure that we are making changes appropriately to the HR systems, providing notice to employees, and preparing ourselves to make sure that we're ready for that increase in the minimum wage and all that goes with it. So with that, I'm going to turn it over to Ashley, and she is going to begin with the Illinois portion of the presentation. And Ashley, I'll give you control of the slides here as well.
Thanks, Dan. So as Dan mentioned, we're going to go ahead and talk about the Illinois employment law updates. And the first one we are going to talk about is the Illinois minimum wage increase. And so as of January 1, the minimum wage increased to $12 an hour. And there are changes for employers where gratuities are paid to the employee. They may pay 60% of the minimum wage, and then an employer may apply for licenses to pay the sub-minimum wage rates to learners and certain workers with physical and mental limitations. The next Illinois employment law update we're going to look at are non-compete agreements. And this update took effect January 1 of this year, and it amends the Illinois Freedom to Work Act, and it provides that a covenant not to compete shall not be valid or enforceable unless the employee's actual or expected annualized rate of earning exceeds $75,000 per year as of January 1. And I know that the Illinois Freedom to Work Act previously imposed an absolute prohibition on the use of restrictive covenants with low wage workers, which was defined as those making less than $13 an hour. And so now they have changed that calculation to annualized earnings of $75,000 per year. These amendments also provide that a covenant not to compete is void and illegal for any employee who an employer terminates or furloughs or lays off as the result of business circumstances or governmental orders related to the COVID-19 pandemic, or under certain circumstances that are similar to the COVID-19 pandemic, unless enforcement of the covenant not to compete includes compensation that would be equivalent to the employee's base salary at the time of termination for the period of enforcement, minus the compensation earned through subsequent employment during the period of enforcement. And then the updates also provide that a covenant not to solicit shall not be valid or enforceable unless the employee's actual or expected annualized rate of earning exceeds $45,000 per year. These amendments also require for employers who are looking to enforce the non-compete or the non-solicit that they permit employees at least 14 days to review the agreement before they're required to sign. And although the employee is free to sign in less than 14 days, should they elect to do so. And the bill also requires that employers advise individuals in writing to consult with an attorney before signing the agreement. And this update to the Workplace Transparency Act took place last year, but since we are discussing non-compete and non-solicits, I thought it was important to bring it up again this year. The Workplace Transparency Act, or the WTA as it's often referred to, applies to employers as defined in the Illinois Human Rights Act. And so it basically means that it applies to all employers with one or more employees. And the WTA affects arbitration agreements, separation and settlement agreements, as well as information requests for the IDHR in terms of charges. And we will address each of those separately in the coming slides. And so looking first at arbitration agreements, under the WTA, employment agreements cannot impose non-negotiable unilateral conditions, which would be conditions that our prospective or current employees must accept to obtain or keep their jobs. And those provisions would prevent prospective or current employees from making truthful statements about alleged unlawful discrimination, harassment, or retaliation. They could require prospective or current employees to arbitrate claims relating to alleged unlawful discrimination, harassment, or retaliation, or waive or otherwise diminish existing or future claims, rights, or benefits relating to unlawful discrimination, harassment, or retaliation. Now, these conditions may be allowed if they are part of a mutual agreement between the employer and the employee, and that mutual agreement is in writing, and it reflects the actual knowing and bargain for consideration from both parties, and it acknowledges that the employee has a right to report a good faith allegation of an unlawful employment practice or criminal conduct to the appropriate government authorities, participate in any appropriate governmental agency's enforcement of discrimination laws, make truthful statements or disclosures as required by law, regulation, or legal process, and finally request or receive confidential legal advice. And so if an employer does not comply with the requirements for mutual agreements, there is a rebuttable presumption that the arbitration condition is unilateral, and unilateral conditions are void because they are against public policy and severable from an otherwise valid and enforceable agreement. Next, we're going to look at disclosures. And so under the WTA, employers must report the number of adverse judgments and administrative rulings entered against them during the previous year. And so for this year, the reporting deadline for 2021 is going to be July 1 of this year. And those reports have several categories, including adverse rulings and judgments issued on claims of discrimination or harassment on the basis of sex, race, color, national origin, religion, age, disability, military status, sexual orientation or gender identity, or any other basis that is protected by the Illinois Human Rights Act. Employers must also report whether any equitable relief was ordered. Next, we're going to look at some additional amendments to the Illinois Human Rights Act. So last year, Illinois expanded coverage of the Illinois Human Rights Act to employers with one or more employees. So essentially, any employer that has an employee is covered by the Illinois Human Rights Act, and those protections were extended beyond the physical workplace. So for those employers that have employees who are working remotely, those remote workers are also covered if they're harassed online or stalked. We want to make sure that employers are paying close attention, essentially, to all off-site events and addressing those off-site incidents as if they had occurred in the workplace. And that amendment last year really focused on the perception. And so perception matters, meaning that the law covers an individual's perceived status. So for example, if an individual or an employee is perceived to be from a certain country or perceived to have a sexual orientation, even if that perception is inaccurate or wrong, they would indeed be covered by those last year's amendments to the Illinois Human Rights Act. And this year, there were further expansions to the Illinois Human Rights Act. And the amendment this year provides that discrimination based on disability includes unlawful discrimination against an individual because of the individual's association with a person who is in fact disabled. And so that would map or mirror the federal requirement where association with an individual who was disabled could also be or form the basis of a disability discrimination claim. And Illinois has done quite a bit of work in the diversity, equity, and inclusion space. I know we've talked about expanding the definition of disability. Illinois has also done a few other things. SB 1730 requires that public corporations report the self-identified sexual orientation and self-identified gender identity of its directors, and that took effect on January 1 of this year. HB 53 requires businesses that use artificial intelligence analysis on video interviews to screen their applicants that they must collect and report the race and ethnicity of rejected applicants and submit that annual report. Now would be a good time to remind employers in the state of Illinois that Illinois does have BIPA. BIPA is the Illinois Biometric Information Privacy Act. And so if you are using artificial intelligence analysis on videos, you should be aware that under BIPA, private entities, including employers that are in possession of biometric identifiers or biometric information, including retinas or face scans, are required to develop a written policy that is made available to the public. That policy should establish a retention schedule and guidelines for permanently destroying those biometric identifiers and information once the initial purpose for collecting or obtaining those identifiers or information has been satisfied, or within 3 years of the individual's last interaction with the employer, and it's whichever of those occurs first. And BIPA has been a very hot area of litigation, resulting in several multi-million-dollar findings. And so for employers that are going to be using that artificial intelligence, it's worth also being aware of BIPA and ensuring that you are complying with BIPA. And then last but certainly not least, on the DE&I space, Illinois has made Juneteenth a paid state holiday. And so for employers that are providing paid holidays, they should also be aware that as of this year, Juneteenth would be a qualifying paid state holiday. And I just wanted to also cover some updates that we talked about last year, but worth mentioning again as we think about leave and what that might look like. So the Illinois Victims Economic Security and Safety Act, or VESA, provides that an employee working for an employer, again, with at least one employee, but not more than 14 employees, is entitled to a total of 4 work weeks of leave during any 12-month period. Employers working for an employer that has between 15 and 49 employees is entitled to 8 work weeks of leave during any 12-month period. And then finally, employees working for an employer that has 50 or more employees is entitled to 12 work weeks of leave during any 12-month period. The total number of work weeks to which an employee is entitled does not decrease during the relevant 12-month period, and permissible reasons to take VESA leave include to seek medical attention for or recovery from physical or psychological injuries that are caused by domestic or sexual violence to the employee or the employee's family or household member. Second, to obtain victim services for the employee or the employee's family or household member. Third, to obtain psychological or other counseling for the employee or the employee's family or household member. Fourth, to participate in safety planning, including temporary or permanent relocation or other actions to increase the safety of the victim from future domestic or sexual violence. And fifth, to seek legal assistance to ensure the health and safety of the victim, including participating in court proceedings related to the violence. This VESA leave may be taken intermittently or on a reduced work schedule. And then just continuing on to the Illinois mandatory harassment training. This would have taken effect as of last year, and so it's a good time to remind employers that they are encouraged to retrain new employees regardless of whether the employee received the required training at a prior place of employment. As an employer or as the current employer, you must independently retain your own records to show that all of the employees at your work site received the required sexual harassment prevention training. Employers may also ask employees to provide documentation that they completed training elsewhere. But nevertheless, employers maintain the responsibility for ensuring the training received elsewhere is compliant with the Illinois Human Rights Act. And if you as the employer are unable to obtain that proper documentation, then you must have the employee retrained. We cannot stress enough that the employer is responsible for demonstrating that all employees have completed this annual training. Employers may develop their own sexual harassment prevention training programs, provided that they meet or exceed the minimum standards, which include an explanation of sexual harassment consistent with the Illinois Human Rights Act, examples of conduct that constitutes unlawful sexual harassment, a summary of the relevant federal and state statutory provisions concerning sexual harassment, including the remedies that are available to victims of sexual harassment, and a summary of responsibilities of employers, so your role in the prevention, investigation, and corrective measures for sexual harassment. For employers that are restaurants and bars, they must also provide supplemental training that exceeds or meets the requirements outlined in the Illinois Human Rights Act. And then last but certainly not least, employers are required to keep a record of all trainings, and those records must be made available for the Illinois Department of Human Rights upon request. This record could be a certificate or a signed employee acknowledgement or course sign-in worksheet, and you may maintain those records by paper or electronically. And then one thing that has been updated, the Illinois Department of Human Rights was promising to publish its own training that is compliant with the standard, and that training has in fact been published and is available on the IDHR's website for employers who do not wish to develop their own program for compliance with mandatory harassment training. And then last but certainly not least, on the mandatory harassment training, there are special rules for hospitality employers, so those restaurants, bars, and casinos. They face additional requirements, so they must provide certain employees with safety and notification devices that may be used to summon help if they are a victim of or witness sexual harassment. And restaurant, bar, and casino employers must inform each of their employees about the protections against sexual harassment and discrimination under both state and federal law. And so giving those employees a copy of a harassment-free workplace policy would satisfy that. And then last but certainly not least, taking measures to separate employees from guests who may commit sexual harassment or other forms of violations of the Illinois Department of Human Rights law, and then accommodate employees who seek legal protection against offending guests. And with that, I think we have a few minutes for questions.
If you have any questions after the presentation today, feel free to reach out to either of us. We're going to provide our contact information at the end of the slides here. And as you can see, we have a host of other resources that you can go and check out: our blogs, the OSHA Defense Report, Employer Defense Report, if you have any mining operations, the MSHA Defense Report, and of course, tune into all of our monthly webinars. We prepare webinars on a host of different topics. So thanks for joining us today. And again, feel free to reach out to either of us. You see our contact information on the screen here. We'd be happy to help. So thanks for tuning in today.